Hi, it's Nate Charles, and welcome back to the Rule of Law Brief. The Pentagon just announced yesterday that it intends to reduce Senator Mark Kelly's retired rank from captain down to presumably commander, and thereby cut his military retirement pay. It's been framed as a show of discipline and resolve. It is neither. It is a legally fragile maneuver undertaken not because the administration believes that it's going to prevail on the merits, and it won't, but because it believes the process itself will achieve a different goal. And I'll explain what that is in just a moment. Mark Kelly is not going to lose his rank. He's not going to lose his retirement pay, and he's not going to lose his retirement status. The law simply doesn't allow that. Military pay is not a privilege that the executive branch may revoke at will. It is a statutory entitlement governed by the Military Pay Act, codified at 37 U.S. Code, Section 204. Once an officer retires honorably at a given grade, the United States owes that officer retired pay at that grade unless it can lawfully establish otherwise. If the Department of Defense administratively reduces a retired officer's rank and thereby reduces his pay without lawful authority, it has withheld money owed by statute. That's not a policy disagreement. It is a claim against the United States resulting in money damages. These claims go to one place, the U.S. Court of Federal Claims under the Tucker Act. The Court of Federal Claims exists precisely to resolve disputes like this where the executive branch has overstepped, and the remedy is the restoration of monetary pay. Now, the legal path to reversal is not dramatic. It is bureaucratic, technical, and well-worn, which is exactly why the administration will lose. What's likely to happen here is something like this. Senator Kelly responds to the proposed reduction. The Department of Defense finalizes the adverse action against him. Kelly then files suit in the Court of Federal Claims, alleging that the government unlawfully reduced his retirement grade and pay in violation of the Military Pay Act and in violation of the First Amendment of the U.S. Constitution. At that point, the case becomes deeply uncomfortable for the government. The court will ask whether the Secretary of Defense has the statutory authority to reduce a retired officer's grade for post-retirement speech, absent a court-martial conviction. It will ask whether Articles 133 and 134 of the Uniform Code of Military Justice can be enforced administratively against a retiree in this fashion. It will ask whether the action was arbitrary, retaliatory, or contrary to law. If the court finds that the reduction was unlawful, and it almost certainly will, the remedy is automatic. Restoration of grade, back pay, and continuing retired pay at the proper rate. This outcome is not speculative, it's pretty routine, which raises an obvious question. If the Secretary of Defense genuinely believes Senator Kelly committed seditious misconduct, why not court-martial him? Because that would be catastrophic to the administration. A court-martial would require proof beyond a reasonable doubt, a very high evidentiary standard. It would also require that the government establish actual criminal conduct, and it would require that a jury of military peers, officers who actually understand the laws of armed conflict, the duty to refuse unlawful orders, and the long-settled principle that service members are obligated to disobey illegal ones. That jury of Mark Kelly's peers would almost certainly acquit Mark Kelly, which would be a PR disaster for the administration. An acquittal would be devastating to the Secretary's authority. It would publicly establish that the military's own justice system rejects the claims that Kelly's conduct was criminal. It would not merely defeat this action, it would delegitimize the narrative behind it and delegitimize Pete Hegseth and Donald Trump in the process. The administration knows that. That's why it's chose an administrative shortcut instead of a trial. Ultimately, this is a face-saving maneuver by Pete Hegseth. The real danger here is not that Mark Kelly is going to lose his pay or anything else for that matter. He's not, and the courts are going to see to that. The real danger is that this is a deliberate attempt to chill speech, particularly among veterans and retired officers. This action sends a carefully calibrated message. If you are a retired service member who still receives military pay and you publicly criticize the legality of U.S. military operations, the government will come after you in some way, shape, or form. Whether the punishment ultimately survives judicial review is almost irrelevant. The process itself is the punishment. And we know this because Pete Hegseth's own personal attorney, unfortunately, a 2002 graduate of the U.S. Naval Academy, has said so. Most veterans do not have Senator Kelly's resources, visibility, or his legal team. They see the threat, not the outcome. They see a Secretary of Defense labeling constitutionally protected speech as sedition and initiating punitive proceedings anyway. The intended audience is not Mark Kelly. It's every other retired officer who might consider speaking up. That is textbook chilling effect. And unfortunately, there is also a secondary danger embedded in this maneuver, and I don't think it's accidental. When the Court of Federal Claims inevitably overturns this action, restores Mark Kelly's rank, restores his pay, and declares that the government acted unlawfully, and it will, the administration will not treat this as a natural legal correction. It will treat it as an opportunity. This narrative is almost certainly already written. activist judges, unelected court protecting the elites, the judiciary undermining accountability. By choosing an administrative route that guarantees judicial review rather than a court martial that risks internal military repudiation by a jury of Mark Kelly's peers, the administration preserves its ability to attack the courts when it loses, something that is already a significant line of operation in this administration's authoritarian playbook. Seen clearly, this is not confidence on the part of the Secretary of Defense. It is damage control. It is panic management. This administration knows it cannot prove criminal wrongdoing beyond a reasonable doubt. It knows it would lose before a military jury. So it has chosen the only path that allows it to punish speech in the short term, intimidate others in the medium term, and blame the judiciary in the long term. Mark Kelly will be fine. That's not the metric of success here. The metric is whether fewer veterans speak next time, and whether the public is primed to distrust the courts when they attempt to enforce and apply the law. That's the real fight.